I'm gonna let them all in. Good afternoon, everybody. We're going to give it just a couple minutes for everybody to join. We have a lot of people on this call today. So if you guys want to put in the chat, what part of the state you're from, how long you've been a guardian, that would be great, but we don't have time to do formal introductions across the board. And we're just going to give it a minute or two, and then we will turn it over to Darren, and he can let us know all his good information. I don't know. I was just telling Darren, I don't know if Teresa will be with us or not. She was having some technical difficulties, so we'll see if she ends up showing up. But she's having some computer issues this afternoon, unfortunately. Okay, I'm going to give it just a minute more, and then I think we will get started. And then as we're kind of going through everything, like I said, we're going to keep all the questions to the end. You guys are welcome to put the questions in the chat as you go. And then we will circle back and leave time at the end for you guys to ask Darren some very important questions. So it looks like we got Melinda from Central Florida. And we have Robin Marion from Lake and Citrus. She's been a guardian for 2 years. Robin's here she's in Brevard County. She's been a guardian since 2011. And hold on, I'm just admitting a few last minute people. Okay, Darren, do you want to introduce yourself and talk about who you are and what you do?
Absolutely. As she said, I am Darren Vermost, and I am the president of Vermost Insurance Agency and Probate Bond Pros. And one of our areas of specialty, of course, is working with attorneys and professional guardians in the state of Florida in terms of their guardianship bond needs, as well as we created a special professional liability policy to cater to your specific needs. So we specialize in this. We do this every day, all day. And so we understand what you guys go through, and we appreciate what you guys go through.
Oh, it looks like Teresa joined. We got a few more people joining too.
Hey guys, I am so sorry. Oh, geez. Running around with my hair on fire.
That's okay. We got it, Teresa.
I go to Wells Bank for what should be 10 minutes, 45 minutes later, for Pete's sakes. Anyway, you all know how this goes. Okay.
So I asked everybody to introduce themselves in the chat, and we are holding the questions until the end, but we'll leave some time for that too.
Fantastic. Fantastic. Okay. So it's 3:05. This is super important information. So we're going to drag our feet for just a second or two to give anybody else with technological problems a chance to get on, because this is just one of those days. So just to tell you guys real quick what brought us to this. So one of our guardians, her name is Diana Shields, and she took some cases that were successor cases of bad guardians. So in those cases, they were the Rebecca Furley cases, where Rebecca Furley had been removed, and Diana accepted these cases from primarily Orange County, but I think there was another county involved. What brought all this to bear, having Darren to come and talk to us and explain this issue, is whether or not the bond companies and or the error and omission insurance companies are looking at a guardian who takes a successor case from a bad guy guardian different than they look at a guardian who just takes a fresh case. That was one of Diana's experiences with some of the underwriters of some of the E&O insurance people. So all this has been going back and forth. Darren, Diana have been on the phone multiple times, and I said, well, we need to get this out to everybody. So that's what brought us to here today. So we still see more people joining. I'm going to wait another minute or two. Got lots of people from all over the state, which is exactly what we like. We've got real new guardians. We've got very experienced guardians. Cool. Okay. All right. So I think I don't want to waste more time because there's so much to talk about. So Darren, I think are you ready to go, or do you need any more tech stuff done?
I just got to start sharing my screen and we're ready to go.
All right, Julie, you ready?
Yep, I'm good to go.
All right, then let's just go, because I don't want to take it. I know some people are going to come in late, but that's just the way it is. So Darren, fire away, buddy.
All right, let me start sharing here.
All right.
All right, can you see my screen?
Not yet.
No.
Oh, don't you just like it when it works?
Had it a
Love-
minute ago.
I know, we had it a minute ago, didn't we?
Yeah, when we tested it, it totally worked.
Let's try it again. Zoom likes to work when it wants to work. All right, let's try it again.
I think it's gonna work this time.
Are you feeling lucky?
Yep, yep, go ahead and put yourself in yep, there you go. You're good to go, Darren.
All right. So what we're going to talk about today is what Teresa already alluded to, is what happens when somebody takes over some bad guardian's work and can they get professional liability? And then we were having the question, what is professional liability? Well, I hear it called E&O insurance. I've heard it called professional liability. I've heard it called MPL. We're going to get through all that so you guys understand what it is, what it protects, what it doesn't protect, and how you can get it and why you need it. And I will promise you, I will leave plenty of time at the end for questions. So we're going to do this on a basic level so you understand, because there have been some issues recently, not just Rebecca, there's been some in my backyard that I personally have had. I had 26 bonds on somebody who is sitting in the Florida State Penal Colony right now.
Oh.
So I know all about this. And yes, we can get you bonded and we can get you professional liability. We just have to know what we're talking about and how to go about it and why it's so important for you. So welcome to our world. We're here and we want to make sure you guys are protected, because I don't care what the media says, you guys do some amazing work and never get the credit, and all you see is the bad stuff on TV. So I want to say thank you to you guys, but I want to make sure you guys are protected because you need it, because they're gunning for you. So briefly, what we're going to cover today is we're just going to go over a few things here. It's just lost. Like I said, when Zoom works, Zoom is great. When it doesn't, it's not so much. There it goes. It's having one of those days. So we just want to talk about what it is, why you need it. We're going to cover how do you understand it, because it is different. It's not your typical insurance policy you're used to dealing with. And there's some unique concepts we want to talk about. We're going to talk about some actual claims. It happens. And we're going to talk about what's covered, what's not covered, and why it's important for you. And of course, then what can you do to protect yourself, not just with insurance. So why does this matter? You guys have some pretty high responsibilities. You are taking care of people's lives, their property. You're acting as a fiduciary and have strict liability that you need to be paying attention to. One wrong mistake can wipe you out financially. And we don't want that to happen, because what you guys do, like I said, you guys do great work and we never see it, nor does the media want to hear about it because it doesn't sell advertising. We've seen some claims. Believe it or not, on professional liability, the insurance company must defend you. I call this prepaid legal. Regardless if it's a sham, regardless if it's frivolous, they have to defend you. So you're doing is nothing but buying prepaid legal. And we use that as a way to protect your assets. Because remember, most of the time when you're getting put on these cases, it's you personally, not your business. So this gives you an opportunity to protect yourself while you're doing this great work. And then, of course, we want to protect your reputation, because if you have a bad reputation out there, you're never going to get a case and you're going to be out of the business. So what is professional liability insurance? Well, it's also known as E&O insurance. So what is it? Tomato, tomato, roof. It's all the same. It really is the same. It just protects you if there's a claim of negligence or failure to perform your professional duties. That's it. It's all the same. We have developed and we specifically tailor our coverage for you guys. And I'll show you specifically whether you use us or any other provider out there. These are the things you need to do to make sure that you are protected properly and why you need this. And of course, like I said, it's prepaid legal. The insurance company must defend you. It's called the duty to defend, and it will cover the attorney's fees. It'll cover court costs and any settlements against you. So, as I said, this is called professional liability or errors of omission. It's both. If you look at the definition within the insurance policy under section S in the definitions, paragraph 1, negligent act, error, omission, misstatement, misleading statement, neglect, breach of duty, or personal injury is covered. That's why you see these names, professional liability, it's one and the same. Doesn't matter. You're talking the same policy, the same thing. So let's just get that on the table so we all know it is one and the same. So if you hear somebody say, well, you need E&O insurance. Okay, great. It's professional liability. The formal name is professional liability. Normally, you're going to hear that from lawyers. They have their malpractice insurance. You have doctors that with malpractice. That's all professional liability. But for what you guys do, we call it errors and omissions or professional liability. That's all the same thing. It's just what does it cover? Oops, it jumped. Let me go. Oh, there we go. So everybody, here's the other thing I hear. Well, I've got general liability. I'm covered. Nope, you're not. General liability is only going to cover property damage and bodily injury related to your business operations. It specifically excludes professional exposures. That's why you hear doctors, they have their liability to protect their practice for slips and falls. Then they have their medical malpractice for errors that they make as a professional. They're two separate policies. It's no different for them as it is for you. You would have a general liability policy, and then you have your professional liability policy. So an example, in the doctor's office, somebody slips walking into the parking lot. That's covered by your general liability. That has nothing to do with you as a professional or the doctor as a professional. That would be covered underneath of something else. But slips and falls, that's where you're going to see the protection underneath your general liability. It could be underneath of a homeowner's policy if you have proper endorsements. It could be a commercial general liability policy that you have because you have an office within your house or a separate location. Whereas your professional liability policy is going to protect you from your professional services where you're paid for a fee. Next question I always hear, but this is a pro bono case. Am I still protected? The answer is yes. You are still protected because it's your professional services. It's going to cover anything neglect, errors, omissions, or misleading statements, as we saw the definition. That's where your professional liability is. They are two separate and distinct policies, and they rarely ever cross over. There's a couple cases, hairstylists, believe it or not, we can get the professional liability for a hairstylist included on the general liability policy for a small fee. It's not a big exposure. You guys, because you have a variety of exposures, you guys do healthcare, you're doing financial, you're doing money management, you're doing all these other things. That is not going to be covered anywhere from a general liability policy. We want to make sure that what you do is protected. So what are common risks for you? Well, there's all kinds. Biggest one we see, financial mismanagement. That is the biggest exposure you have. Handling the board's money, flat out. What if you breach your fiduciary duty? You didn't act on their best interest. We're starting to see that come to life here, such as misdealing with some property. It's happened in South Florida. It's definitely out there. They're looking for it. And yes, they are looking for the insurance to pay off and make the ward whole because of it. And if you don't have professional liability, you're paying out of pocket. Court order violations. This one is happened in other states. I haven't seen it yet in the state of Florida, but what happens in other states does spread to Florida, believe it or not. These attorneys talk. This is not just, oh, yeah, no, it happens. They go to conferences, they talk and say, hey, I had this claim, this is how I got it. It's coming to Florida, I'm telling you now. Get ready. And if you miss a deadline, we are humans. The last time I looked, every one of us is a human being. If we make a mistake and you miss a filing of, say, a tax return, or you miss filing a report for taxes or anything else, if you miss it, well, you made a mistake. This would protect you if there was some kind of loss. So as a case study, this is an actual case that happened. Is somebody actually, they had a $500,000 account at a brokerage firm and they did management. And we know what's happened with the market recently. ups and downs, and they lost a lot of money. And the family will say, trying to be nice, they sued the guardian for negligence and the financial loss because they did not do prudent investing on behalf of the ward. Now, if you have professional liability, you can turn in a claim. The insurance company gets you an attorney. They'll defend you. If not, you're doing it yourself. So what happened in this case? They settled. They won't give us the dollar amount, but we know they paid over $30,000 in legal fees. This is the good one. The family dispute. You never have any disputes at all with any of your wards or the family, do you? I didn't think so. So what happened is the family alleges, keyword alleged, favoritism and misuse of the ward's funds and filed a lawsuit against the guardian. Well, needless to say, it did go on for a while. And of course, when things drag on for a while, what else happens? Attorney's fees go up. So it was actually dismissed. But the guardian incurred over $40,000 in defense costs and did not have.
Wow.
Wow. As I said, professional liability is prepaid legal. So this is why have, well, this is what it's going to cover. Your negligence. You erred. You're a professional and you missed something. That's what it's for. As I said, the legal defense, that's always key, and it will pay the settlements and any judgments up to your policy limit.
Darren, let me stop you for 1 second. We've got people mentioning in the chat that they can't hear. I just want to make sure that that's only one person. Anybody else having trouble hearing? No? All right. Okay, so Nicole, it might be on your end. Sorry to interrupt you, Darren. Go ahead.
No problem. So your a professional liability policy is going to cover all these avenues for you to make sure that you're actively protected. Does it cover everything? No. But here's what's not covered. Believe it or not, criminal acts. If you are creating and committing a criminal act, it is not covered by any policy. That is a flat out #1 exclusion. Boom, done. If you deliberately do something wrong, you commit fraud, dishonesty, again, that's not covered. That's not what it's designed for. This policy is designed to protect when you make an honest mistake. It does not cover property damage or bodily injury. And it does not cover prior claims. Now, with prior claims, I'll put a little caveat on there, and I'll explain it just a little bit, but we can get some coverage for prior claims based on when you started the policy. So it is possible there, but if you take out a policy today and you've known that you had a claim from 2 weeks ago and they do their investigation, there's no coverage for that. You can't buy it after the fact or retroactive. Nobody's going to allow you to do that. That's too late. All right, here we go. This is my #1 question I get from everybody is how much coverage do I need? There is no right answer, guys. It's going to boil down to each person's going to have different circumstances. How many cases do you have? Well, this person's got 1 case, but it's a $20 million case. This person has 20 cases, but their total exposure is only $40,000. This person does nothing but just basic guardianship type work. This one has healthcare surrogates. This one does trustee work. This one does probate work. This one does money management. This one does healthcare advocacy. Everybody is different. There is no right answer. The wrong answer is you don't have it. The right answer is you have something there. If you're going to expand your practice, i.e., are you going to add extra services to your wards? Are you going to offer them something else there? Then we have to look at that and take that into consideration. And what is your caseload? Like I said, everybody is different. There's no right answer to this. The wrong answer is you don't have it. The right answer is, yeah, we actually have it. So I like to show everybody how this works as prepaid legal. This is so we get down to brass tacks. It makes it really simple for you. So let's say you're a professional and you don't have professional liability. Well, an hourly rate for some attorneys, we're just going to pick, and this is on the low side, so, but I do that for a purpose, is $225 an hour. An average premium is about $1,750. That equates to about 8 hours of legal counsel. But what if you had a professional liability policy that had $500,000 of limits at the same $225 rate and the $1,750 premium for it? You're talking 2,222 hours of legal counsel. Which way would you rather go? I think it's pretty self-explanatory. Something that I was just brought up recently, somebody said, well, I've got tail coverage. I said, really? And I said, do you know what it is? No. Well, the way professional liability policies work is they're what's known as a claims-made policy. So that means we cover when the claim is filed. So whatever policy is in force at the time that claim is filed is which policy is going to respond. Not when it happened, which date was the claim filed. Unlike your homeowner's policy or your auto policy, let's say you had an auto policy from 2 years ago. All of a sudden you get served with a notice from the accident. The policy you had enforced back 2 years ago is going to be the policy that's going to defend you, not your new policy that you switched to 6 months ago.
Oh.
On a professional liability policy, as long as that policy is in force when that claim is made, it is covered. Now, what's the downside of that? Let's say you get out of the business, you decide to retire. Everybody likes to retire. If you do not purchase, keyword, purchase the extended reporting period, just like the name says, extended reporting period, so you get extra time to report the policy or the claim, we refer to it as tail coverage. So after you stop working, you can purchase an additional period of time to have claims reported and covered by that last policy. And it is a purchased coverage. It's in the policy what the cost will be depending upon how long you purchase. You can purchase for 12 months. Some will offer 3 years. Some will even go as high as 5 years. Of course, the longer the duration that you can purchase, the higher the premium will be. And I can tell you now, the 1 year purchase is usually the 100% of the premium you paid on your last policy term. So what happens if you don't have it? Like I said, you're the insurance company. You're self-insuring for any claims that have happened after you terminate the policy. So what can we do in terms of protecting yourself if you're not interested in this? Well, there's some things you can do. First and foremost, document everything. Document, document, document. If it's not written down, it didn't happen. Period. So, well, I just had this conversation. It was all verbal. Send a follow-up email summarizing our conversation. Now it's written down. Now you know it's not verbatim, but guess what? You have something in writing that you can refer back to. There's no questions. Start using calendaring system. We all have cell phones nowadays. They come no cost, calendaring systems in there, follow-up systems. You can use those so you don't forget. There are more expensive platforms out there that you can purchase, but just have something to help you. We're all so busy anymore. Communicate regularly with your wards and their family. That is a problem for some of us because we know some of the family members are crazy. I get it. I understand it. But we still have to document and record everything. That way they can never say, well, you told Sally this, but then Johnny says you did this. Stop. Communicate with everybody. Document it. There is no problems then. It's that simple. And of course, seek legal counsel. Don't do this yourself. So I can't stress enough the power of the documentation. Even in my business, we get sued all the time. And if we don't have it in writing, somewhere documented where we can prove it, we lose. It's going to be no different for you. And as we tell everybody in my office, If it's not written down, it's not documented, it just plain didn't happen. Whether it's a phone call, whether it's an email, whether it's whatever, write it down somewhere, some way. It's okay. Now, the downside of that is do not use voice recordings. HIPAA violations. Do you know where it's being stored? Do you know who's listening to it?
Mm.
Do you think talking to Alexa is a good thing? Nope. Even talking to Siri is not a good thing. So please be very careful with using your voice notes. But they say, oh, it's documented. Yeah, it is. But guess what? Now you just got yourself a HIPAA violation. That's really going to be expensive, and that's not going to be covered. So what can we do when we're purchasing this coverage, and how do we go about it? Well, the first thing is we need to look at what's the definition of professional services. First and foremost, this is what you need to make sure you understand. So I'll get to that in just a second. Retroactive date. What's a retroactive date? Well, if you've had multiple policies and if they were written correctly, you can change your retroactive date, which means how far back will they go to cover on my claims. If you're just taking it out today, your retroactive date becomes today. If you've had a policy for 10 years, if done correctly, your retroactive date is 10 years ago. So they would cover everything from 10 years ago to current. That's how you get covered for issues previously. But if you just take it out today, you're out of luck. And number 3 is we look at the definition of who's an insured, because I know some of you are by yourself, others of you use third parties, some have independent contractors, some have employees. So we want to look at all that. And lastly, we want to look at what those exclusions are, because you may get a cheap policy, but if you compare Walmart to Saks Fifth Avenue, they're both dresses, but they're 2 totally different dresses. So we want to make sure that you know what's covered and what's not covered. So when we're looking at, what's the definition of professional services, we want to make sure those specific duties that you do are listed on the policy, and review this every year. What happens if in the middle of the term you decided, oh, I'm going to start doing trustee services? If it's not on the policy showing that you do as a professional trustee services, and then you go, whoops, they're going to say it's not listed in the policy, because insurance companies are going to be quick. When you're talking $1 million, they want to make sure that all I's are dotted and T's are crossed. So if you're just adding something new, we got a potential of an issue there. And we want to look at what's going to be covered. And of course, we're going to look at the gaps. So how is it defined? This is the absolute bottom line. If you take nothing away today, this is one of the most important things you need to know of, is how is it defined? Now, this is a screenshot from a current declarations page from a policy that we just issued in our offices. And this says the insurance profession under item number 5 is a trustee that's been court appointed or a trustee who's non-court appointed. That's not a good thing. Last time I looked, most guardians do a little bit more than that. But that's all the space that the insurance company had in there. So you have to start looking and digging into the policy itself. And further on, way back under endorsement number 6 on this policy, it changed the policy wording to make sure that it's defined as a guardian, a fiduciary, a case manager, a power of attorney.
Important.
Yes. And a healthcare surrogate. Now, this is just one person. This was an actual policy. You can see the date on it was April 17th. This is an actual policy, but that's great for this person. Teresa could be something different, have more exposures, or she could have less. Mm-hmm. But if you just look at the front page, I wouldn't be happy with that. But you have to read the policy. And let me tell you, if you got insomnia, I can fix it overnight. I'll let you read an insurance policy because it's going to put you to sleep. It's better than counting sheep. But you have to read the policies. So here's what the word of an insured means, because it says we're going to defend the insured. So the question is, who's an insured? Well, under this policy, it's the named insured. So people say, should I put the policy in my name or should I put it in the business? Both. we're going to make sure, because we want to be listed as the named insured. Last time I looked, in the state of Florida, all guardians are listed as a personal name unless you're one of the public guardians.
Well, we'll talk about that at the end. There is a little bit of a new nuance to that, but go ahead.
Oh yeah, I know. But the vast majority are going to be listed as your name.
Yeah.
So you want to have your personal name there to make sure you are protected, as well as whatever entity you decide you want to have, whether it's an LLC, sub-S corporation, whatever your CPA and attorney set up for you. And it specifically lists, it says any past, present, or future director, officer, owner, partner, member, manager, or employee. So your employees are protected. And then if you look at number 4, it says an independent contractor, but only while they're performing professional services on your behalf. So if you use that third party to manage, the money management for them, they're going to be protected for you. This is key. Again, this is in the actual policy, in the definition section. I can't stress enough to read the policy. But here's some of the common misconceptions that we see. First and foremost, I need to save money. Well, okay, well, that's great that we're looking at cost cutting here during these times. I understand everything is going up, but by doing that, we've just set ourselves up where our personal assets are going to be subject to having to be paid legal fees to defend ourselves. You can't go into court and defend yourself. You're going to have to hire an attorney. Confusion on the general liability. Is it general liability or is it professional liability? Each claim is going to be a little bit different, but I'm telling you, most times we're seeing for you, what your exposures are is going to be under professional liability exposures, not general liability. Although I did see a possible case under a general liability policy, they got lucky. Somebody was sitting in a doctor's office, sitting on their laptop, doing their notes, getting caught up. That would never happen while you guys have somebody in there. No, never. Somebody tripped over the charging cord in the doctor's office. Got hurt.
Oh.
Yeah. Oops. That would have fallen underneath the general liability because there was no professional services being rendered.
Okay.
It was in the operations of their business. So small business, work from home, home office, there are very inexpensive policies that are available that can give you that coverage to make sure you're protected. Everybody says, hey, I'm wonderful. I understand it. You guys are, but we do make mistakes. Even I make mistakes. So it happens. And it's just how much in legal protection do you want? And of course, there are no court requirements that says you have to carry this. So I hear, well, the court doesn't require it, so I don't want to do it. Okay. I'm not going to force you to, but I don't recommend it. So what can we do? How can we get around this and how can we get better? Just like today, start going to the associations, coming to these meetings, learning. This is where you find out all this stuff. Get better. If we're not learning every day, we're losing. And things are changing quickly. Build your network of peers and learn the best practices. So what I want you to know is know your risks today. What are the risks? Your exposure as a professional fiduciary out there. Anything you're doing as a professional services is what's at risk. So know that risk. Know how you protect yourself. Make sure you get the proper coverage. That means knowing your definitions, making sure what you do is out there. Look at that policy and work with somebody that's reputable. Document, document, document. And lastly, review regularly. This is not just fire and forget. What happens is we get complacent. Things change. Oops, I forgot I'm now doing this kind of work. And then it's not listed. You're not covered. They're not going to give you automatic coverage for that. They're going to look, and if it's a big case, that insurance company will get off in a heartbeat. Now, there's some new areas out there that we're starting to see, and that's in the artificial intelligence.
Oh, gosh.
Yes.
Wow.
We just had a case, and I'm not joking, it was in the paper this week here locally. An attorney used artificial intelligence to draft his brief in a federal court. Artificial intelligence has a tendency to hallucinate. Yeah, they're not taking LSD, but it just creates stuff out of thin air. It created fictitious sightings, fictitious cases, and the attorney filed it with the federal court. Unfortunately, that is not covered underneath of a professional liability policy.
Mm.
He's one lucky individual that he got his hand slapped. The judge could have filed sanctions with him. And that's just a local case here. It happened in the Middle District over in Tampa. Oops. Please, please, please review, network, learn, keep growing what you're doing because things are changing. So now I'm going to open it up for questions. I saw a bunch pop up. So I'm going to let Teresa fire away with the questions.
Okay, great. Okay, one thing I'm gonna do real quick before I start the questions, I want to tell this story because this is the story that made me understand that even though I think I am the absolute most perfect guardian who does everything right, never forgets everything, never misses a deadline, this is the story that I heard that finally resonated with me of why I need E&O. Hear the word error or omission. Okay, so here's the story. You get appointed on a Friday in August in Florida, 2 o'clock in the afternoon, you get letters of guardianship. At 2:05, lightning hits the 4-unit rental property that your ward owns solely herself. Damages most of the units and injures people. Were you the guardian at 2:05? Yes. Could you have done anything about this from a practical sense? Did you even have time to physically get to the property, see if it was insured, all that stuff? That's the first time I truly understood that even if you do everything right, there are things you cannot control that could cause lawsuits. The 4 beneficiary kids or the 5 beneficiary kids to this unit, because by the way, the ward stopped paying the insurance. It's an uninsured asset, which happens to us all the time. I want you to hear that story to get it in your head because I kind of had like a block because I said, well, I don't do anything wrong. I don't miss deadlines. I don't need this. I just want you to hear when I finally got my thick skull to understand, oh, that's why. Okay, now, great question from Cindy Kramer. So her first question was, she used the word personal injury for wards, employees, and ourselves. Go ahead and respond to that, Darren. I think I know the answer, but go ahead.
Okay. Personal injury is not what you think it is. It's not, oh, I hit somebody. It could, but we're talking libel, slander, things like that, that falls underneath of personal injury in the definition underneath of a general liability policy.
Okay. Her second question, which is really interesting, when we have a bond for our wards that each ward pays for, can our wards also pay for the liability insurance? So Darren, go ahead and make your comment and then I'll suggest my comment.
Okay. When we're looking at a bond, let's back up and say, okay, what is a bond? A bond is nothing more than a financial guarantee from a surety, most times an insurance company, that's guaranteeing that the ward's assets are protected so that if the guardian decides to go on a round the world vacation on a cruise and use their money, that the ward's reimbursed for that. And then they go back to the guardian to get reimbursed. That is where a bond is. Professional liability is going to be something else where a lawsuit is going to be involved. So they are 2 different things. Because remember, on a professional liability policy, do we list specifically each and every ward that this is protecting? No, it covers all. I have not seen yet where any judge is going to sign off on a court order allowing you as the guardian to have that ward pay for it.
So the interesting comment to that is, Darren, we happen to know a guardian who just recently took a $20 million guardianship.
Yes, we do.
Yeah. And that was a conversation I had with that guardian. And I said, well, I would normally say that no, the judge would not accept you using wards either individually or as a crew, 10 wards to pay for your professional liability insurance.
Right.
However, because accepting a $20 million case has so much unique risk, that might be something to look at. So, but as far as a standard situation, if you think about it, do you spread the cost of your cell phone, your business cell phone, over your many wards? No. Do you spread the cost of your subscription to the software you use to manage your cases over all the wards? No, those are business expenses. I think it would be an extremely rare situation in which a judge would authorize the payment of your either company or entity or personal liability insurance to be spread over the wards. Not likely. Right. Next question. If I'm the individual guardian and I work for my company, as do other employees who do care management, can I get insurance for them too, like a blanket policy, which I think Darren very much already explained, but remind them again, Darren, on that.
If they are listed as an independent contractor and an employee, they are covered only for the services they are providing for you at that time. It's not going to cover them working for Sally over here doing trustee work, money management. It's only going to cover them while they're doing work for you for that specific work.
Okay, perfect. So guys, if you've got more questions, if you would prefer to say them verbally, you don't want to say it in chat, you can raise your hand and we'll try to keep our eye out for your little yellow hand. You can add more questions. I'm going to add a couple more comments. Darren, first of all, I want to thank you so much. You put this into digestible information, and I fully feel like I'm understanding this. I hope everybody else is. Never heard of the word tail before as it relates to this. So that's fantastic, because now I understand. And when you mentioned retirement, I know a lot of guardians close to retirement. So if the policy is based on the date the claim was filed, not on the date that the quote unquote thing happened, that's right. Fantastic. So, because we have to keep our records for up to 3 years after discharge of both person and property. Same thing for estates, same thing for trust work. So the fact that we can buy like retirement coverage for like 2 or 3 years after we're not actively working anymore, and we could still have protection, makes me feel super comfortable, because I didn't know that was an option. Okay. Yes. So my other comment to you is, this is becoming a new thing. New to me anyway. There used to only be 2 groups of guardians: professional guardians who operated their business individually. Maybe from a tax point of view, they were a sub or LLC, but a tax point of view. But I'm just talking about from guardianship services. The guardianship letters were in the name of that individual person, not a company, not an entity. So that's now starting to change. There's a couple already organizations in the state of Florida who are, the entity is getting the letters of guardianship instead of the person. And these are entities that are not public guardians. So this is kind of the new era of guardianship, which honestly, that's what I wanted my whole 30 years. I always wanted a way that the letters of guardianship were not in my individual name. This is not popular everywhere. And in some circuits, they will not allow it. The judge says nope. And my favorite judge in Seminole County, who, when I asked her about this 20 years ago, she said, nope, I want a throat to choke. So she never agreed to that. But that's going to relate to this. But from everything Darren said, I think it's covered because it's the entity, it's the individual, it's the employees, it's the 1099 contractor. So that's great. Cindy, when you say statute now says corporate guardians, well, are you talking about the statute under the public guardian statute? I think that's what you're talking about. And corporate guardians is kind of a non-existent thing. Corporate trustees, that exists, but a corporate guardian is kind of a new animal. So Cindy, if you can bring up that statute while we're talking, I'd love to actually look at that. Okay, so first of all, let me make sure. Anybody waving their hand for questions or thoughts?
And one thing to follow up on that, Teresa.
Yep.
What I'm hearing on those corporate guardians is they're also going to increase the bond requirement to $250,000.
Okay. Versus the 50. Okay. Yes. I've got Cindy. I see your hand shaking. Go ahead, darling.
Can you hear me?
Yep.
Yes.
Just fine.
Okay, so the new statutes, where it used to be that there was only a not-for-profit guardian, which was the public guardian, now we have for-profit corporate guardians
Yep.
in the statutes, and that's what you're talking about, Teresa.
Do you happen to have that number in front of you, Cindy, by any chance?
No, I don't, but I
Okay.
can pull it up for you later, but I know that it's there because we
It is.
considered it too.
Yes, and this is a big business decision going forward as a guardian. So I love that. Okay, let's go back where when we started talking about the problem of the successor guardians when you take over a bad guy guardian.
Right.
Darren, can you elaborate on that a little bit?
Absolutely. There is, I shouldn't say it is. There's one company out there that in their application specifically asks on the application if they are taking over any cases for somebody that's had some issues. The companies that I work with, and there are other companies out there that I have built this specialty program for, we do not ask those questions. We do not have those issues. If you took over Rebecca Firely, if you took over, Tracy Samuel's cases, bonds were replaced, policies were replaced. It's not a problem.
Okay.
You
It
just
has
have to
more to
work
do
with
with-
somebody that's going to explain that.
It has
and-
more to do with who the insurance company is. I think one
Yes.
name that was thrown out there, I'm not going to repeat it, but one name in particular was
Correct.
a company that would not allow if the prior guardian had been removed or was a bad guy, or they would limit things. They would start putting limitations on it.
Yep.
Okay. And I do know that years ago that had been bopped around in the bond world.
Yes.
So meaning that, let's say I become the successor guardian of a bad guy guardian who stole money, and they're pursuing the bond that guardian had for that ward. I'm now the new guardian with a new bond, same ward.
Mhm.
And there was some comments about that at the time, but they were able to keep it separate enough so we were able to stay clean. But I understood the risk to the insurer.
Right, but in the bonding, there's just some additional wording that we put on it, and it limits anything that's happened prior to that date that bond was issued on your behalf.
If that,
We make it very clear
if
that
they
there's
did bad stuff, it's not, I didn't do the bad stuff.
correct.
Okay. All right, Diana has had this very difficult case, and honestly, she brings this up every time because Diana is a pickle. I'm going to read this to y'all. I know the background behind it, but anyway. Is it reasonable to obtain an E&O insurance as a guardian, which includes a ward who has a ward who resides in their own home and refuses to cooperate with the guardian regarding obtaining house insurance, and when the proposed insurance company will only state the guardian needs to have, I think what she's talking about is she can't get the insurance stuff done, like the 4-point inspection, that would
Right.
actually show the house. So the question here is, when you have a ward that's completely uncooperative and you've done everything you can with the courts and law enforcement, and Diane has, believe me, she fights this battle every week with this ward. She's had everybody there and their brother. So she is still responsible for a house as uninsured. She hasn't even been inside the house.
Right.
She's still responsible for that ward, trying her hardest, but because the ward is completely not cooperative, the house isn't really protected.
Correct.
From an EO point of view, if she's done everything she can to protect that ward and ward's home, but still hasn't accomplished it, would that coverage work, do you think?
Well, remember what I said. This was prepaid legal. So they can make the claim. You send it to the insurance company. They now have to defend you. And if you have all of your documentation, which it sounds like in this case, she's been to the court, she's done,
Tons.
where's the claim?
Okay.
She can't, physically barge in.
Right. Law enforcement won't even walk her in the door. Cindy, I see your hand up. Let me answer these other two. I'll come right back. Monica says, isn't corporate guardians like Catholic services? Well, Monica, yes and no. Some corporate guardians, some public guardians have two sides to their house. They have a for-profit side, like any other professional guardian, and they have a not-for-profit side. I believe that's how Catholic services operated, but I don't know for sure. But they can be either one, a big not-for-profit, or one, a not-for-profit separated into two piles. So I hope that answers the question. Cindy is saying, are the policies state specific? Oh, good question.
They do have some pieces in there because they have to comply with Florida law in Florida. They have to comply with Georgia law in Georgia. So it's not saying that you can work in that state, but there will be extra verbiage, another endorsement in there that's going to list that state's requirements in terms of cancellations, payments, whatever it may be. It has to be there. So those requirements will be listed.
Okay. All right, Cindy, you want to come off of mute? No. Okay. All right. Okay. All right. Next question. So this is a really good question because he kind of answered it, but I want it said again. Robin says, can the insurance cover you for the past few years if you get a case against you now from that time? So I think what she's saying is if I get this policy in the month of May, but back in 2024, I had an incident. There was no claim, but I had an incident, and there's now a claim in 2025. What happens?
Knowing most insurance companies, no coverage.
So you had mentioned it would go retroactive if we had the proof that we had prior insurance in place.
As long as you had continuous non-lapsed coverage. So you can change different insurance companies.
Okay.
They're not saying you have to stay with this insurance company. I can change.
Don't have a lapse at all.
Exactly. There's no gap in coverage there. I mean, if there's a small one, maybe you can talk to the underwriter and say, hey, they were on vacation out of the country. They couldn't get it to us. There was a 2-day gap. Will you please continue? And they'll probably say, yeah, that's not a problem.
Okay. Okay.
But as long as you've had that continuous coverage and you have that retroactive date on the policy, it will be listed on the policy. It will say retroactive date. If it says it's going back 5 years, you're good. If it only says as of today, you got a problem.
All right, great. Okay, I want to highlight something you mentioned because I didn't know this. So you said HIPAA is not covered under professional liability. So walk us through how we get coverage if we make a HIPAA error. Do you know?
That is a tough one right now. It really is. We're fighting that one right now. There were a couple policies out there that used to cover HIPAA, but because of lawsuits and claims and such, a lot of them no longer will cover the HIPAA exposure.
Interesting. And your comment you said about the voice recording, I love doing this peer group because I learn something every single time. That has never occurred to me that if I put a voicemail on a sister's recording about the update about what happened with the hospital stay or the doctor's appointment, honestly, that has never occurred to me that could be considered a HIPAA violation because the sister and I talk all the time and we have a good relationship. And you're right. I don't know who the hell is listening to that recording. You know what? This is going to be our new little reminder to everybody because you just taught me something that I never even thought of. So that is fantastic. All right. So more questions coming in. So Darren, is this you? Darren, is your middle name Francis?
No.
Oh, okay. Okay.
Thank goodness. Woo.
Oh, it's spelled I-N. Okay. Darren Francis says there's a wide range in costs of premiums.
Correct.
If I look at changing insurers, what should I look for to make sure a lower cost premium is okay? For example, I am told some insurance companies are much harder than others to get to cover a claim. How does a consumer evaluate things like that? Oh, that's a great question. How do I know, Darren, that you're the good guy? Tell me.
You have to know you need to find a trusted insurance advisor that knows what you do and understands your exposures. Just because they have an insurance license does not mean they understand what a guardian does and the exposures that you guys are exposed to.
Fantastic. What about me doing background check on the insurance companies? Like, you always hear people say Moody and A+ rated, blah, blah, blah. What should I be looking for to know that the insurance company that you're recommending to me are the good guys and do have a good claim history? How do I do that?
There's no real good way of doing that. That's where you have to rely on that trusted insurance advisor to know that they're looking out for your best interest.
Okay.
They're not working for the insurance company.
Okay.
Now, if I work, and I'm not trying to badmouth anybody, but State Farm agents only sell State Farm and they have to preach the State Farm word. Then you've got people that, like myself, that are independent and we represent many different insurance companies. We're not beholden to the one and we don't have to preach them. We're working on your behalf.
Okay.
So,
Cindy, I see your hand up again, hon. Come off of mute.
So I don't understand. We're not healthcare providers. So I don't understand how we could get in trouble for any HIPAA violation because you're leaving a message on somebody's machine or telling somebody medical information, because we're not healthcare providers. I could understand that we're violating the ward's right to privacy, but I can't see it being a HIPAA violation. Maybe Darren can speak on that.
Interesting.
The question becomes, who you want to challenge them? Remember, they can file a suit and file the HIPAA claim. Now you got to defend yourself.
But I
When
think
you
that
say, like,
the definition is healthcare.
Yeah.
And we're not healthcare.
Well, so
It's a
think about it.
gray area.
Yeah, it's super great. So think about it. Let's say you have a client, a ward who has AIDS, and you make mention of this in a recording situation. I don't know what it would be. And that information got out now. And so I think Darren makes a point. Is it clearly not paying attention to their privacy? Yes. Could you be HIPAA violated because you're not a healthcare provider? So here's where I struggle with that. Every guardian worth their salt has taken the socks off of a ward to look at their toes, has pulled the blanket back, has looked at their butt wound on their butt. Every one of us, if you're worth anything, you do that. You're not providing health care, but there's a gray line between that. So interesting. Interesting. All right, next question. Pam says, can the insurance extend to being the personal representative of the estate after guardianship? Great question, Pam. Go ahead, Darren.
Are you listed underneath professional services as probate? Can't answer the question. If it is, covered. If it's not, not covered.
And this
That's
is
where I said you have to review it
super important.
every year at least.
Super important when you change your business model. So let's say you've decided that your cash flow and guardianship is getting difficult and you need to do some services outside of guardianship, care management, healthcare surrogate, power of attorney, trustee. As long as each one of those job descriptions is in the insurance coverage that Darren sold you, or you tell Darren, hey, we need to add this. I'm now doing this work. I'm now doing POA work, or I'm now doing care management work. That's the whole point. And that's the whole point of his presentation, which I want you guys to really hear. This is a specialized policy. If you get a general E&O policy that says professional liability for whatever, you don't have anything. You don't have anything. You need a policy that specifically covers you for the actual risk that you have, because a risk as a trustee is a little different than a risk as a healthcare surrogate, a little different as a court-appointed guardian, a little different as a durable power of attorney. But those titles are now listed on that policy, which means now you're covered.
Correct.
Okay, great.
If it's not listed, it's not covered.
Perfect. Marilyn says, if you do not share with the caregivers you hire to care for your wards and their circumstances, how are the caregivers going to give the best care? Marilyn, 100%. I know what she's saying. She's saying if I don't tell the caregivers that the gentleman has AIDS or he's got a wound or he has this or he has that, that's communication with the care providers. The issue with HIPAA and or privacy is dispensing that information in other ways, maybe not careful, maybe not respectful, maybe not honorable, and then on the privacy side, and then maybe illegal on the HIPAA side. Like, for example, when we have meetings on the peer group, we try to only use the first name of people's wards. Why? Feels like a little bit of violation there. Is it? Maybe not. It doesn't matter. It's easy enough. We're talking about Andy. That's enough. We don't need Andy's full name. So that's the idea. Oh, great question, Sue. Sue says, how about representative payee through Social Security? Oh, that's good. Or VA fiduciary.
If it's listed, it's covered. If it's not listed, it's not covered.
Fantastic. Love that. Diana, what's your question? Come off of mute, babe.
Okay, I don't mean to belabor this point. I just want to get a specific answer, okay? I'm not trying to belabor it. When you say the insurance is legal coverage, they have to defend you.
Correct.
In this particular case, if something happens to that house, there's no insurance. I have this E&O insurance. Their attorneys will defend me if there is a problem with the house situation or the family coming at me or whatever.
Right.
However, does that mean that the insurance will also pay for the house repairs instead of me? Is it just only the insurance, the attorney coverage, or is it the actual repair the house coverage as well?
Well, here's the thing. Number one, given that scenario that you've done everything you possibly can and the insured has not cooperated, they're going to defend you from the suit and it's probably going to get tossed out.
Yeah.
Because they're not going to,
I would hope.
I mean, if you were somehow some crazy jury, it goes to jury and they find that you were at fault and guilty, then part of that settlement could be covered by that policy. The likelihood of that happening, if you have all of your documentation, which it sounds like you have, you can sleep well at night.
Go ahead and get the insurance.
So here, so here's, go back to my story, Diana. Think about the lightning strike on that for rental. Okay. The ward had let the insurance lapse a long time ago. You just got appointed exactly 5 minutes ago. Could the family sue you? Yes. Would your insurance defend you? Darren, am I yes?
Yes.
They would defend? They would defend.
Absolutely.
Would they win? Maybe, because juries are crazy.
Exactly.
And attorneys are crazy. And that is really the point of this conversation. It's not even so much that what you did was wrong. You did everything you could do, but there's still potential risk. So that's really the point. That's really the
And it
point.
says, and the duty to defend does not say only for certain cases. It just says it's the duty to defend, whether it's frivolous or not, they must defend you.
Okay, so now I want to bring up some hot buttons about this stuff. We're not talking, Darren, about criminal defense, correct?
Correct.
Okay, so everybody be clear about that. Rebecca Furley got criminally charged for some of her stuff. She was also civilly sued, I believe, as well. And if she'd had this insurance, she might have coverage on the civil side. But don't get confused that professional liability is criminal coverage if the state's attorney or the inspector general or somebody is criminally charging you. Those are not the same things. Don't get confused.
Correct.
Okay. All right. So I'm looking through the chat here for more questions or comments. If you have one, you can raise that little yellow hand or type it in chat. Or if you want to start talking, just wave your hand. I'll try to see it. Okay. So I do want to make another comment. Many years ago, FSGA was trying to find a good policy for the FSGA members. This was 15, 20 years ago. And we got this policy that we found. Don't even ask me how that came about. Just long story. I purchased the policy, and unlike what Darren told us all to do, I really didn't read the policy very well. To be quite frank and honest, I'm telling the truth on myself. Finally, sometime later, after I wrote the premium check, I started reading the policy. And everything about the policy was actually a policy that was established for people who owned or operated group homes. It was completely a terrible match. It wasn't a good policy. Now, at the time, there weren't very many options. This is many years ago. But it didn't say the very words that Darren is showing. It didn't say things like guardianship, trust, power of attorney. It didn't say any of those job descriptions. It didn't say any of that. Instead, it implied much more on the medical malpractice and personal liability of injuring a resident in a group home. I was very upset with myself for having not understood that I just bought a policy that was completely inappropriate for coverage for me as a guardian. So do not go off of just trusting Darren. Read the policy, read every word, and preferably take the policy to either your financial advisor, your CPA, or your attorney and say, I'm trying to decide whether to buy this insurance. It's not inexpensive, but I think I have liability risks. What should I do? And when you do that, then you'll get their perspective on the policy as well, because you'll now go, oh, I kind of see this is what this coverage is for. And maybe they can bring attention to you like say you've been working with this attorney for a long time and they've represented you in multiple kinds of jobs or positions. Maybe it wasn't court appointed. Maybe you're consulting. The attorney uses you to do some of your skills. So you want to make sure that that label, does it fall under care management? Does it fall under, does the consulting services that you do for that attorney for their clients, does that fall under those proper titles? You're going to talk with Darren a lot about what your company, you and your employees do so that they're under the umbrella of the actual title. Because case management and care management, people perceive those as very different words. Pam, you got a question?
I do.
Great.
Just want to reiterate or ask or try to get understanding. So if I have 2 cases 10 years old, I get a policy. It starts the day of because I don't have any existing ones
Correct.
at all. So anything that would have happened in the past, I'm not covered. It would
Correct.
start the day of.
Mm-hmm.
Okay, I just want to have clarification.
And then if you keep that, let's say you keep that policy for 5 years and then you retire. And then when you retire, you go to Darren and you say, okay, I'm retiring, but I want it to extend past my work, because if they go back 2 years, 3 years ago, during that 5 years that you had the insurance, you actually had the coverage,
Yep.
but you decide to add 12 months or 24 months after your retirement to make sure that retroactively you're covered. That's that tail coverage, which again, Darren, I appreciate that so much. I knew nothing about that. Does that make sense to everybody?
But except in cases like that, what if that's great if it's just 2 years in that area. If they go back 10 years,
Your
and
SOL, your
2
SOL,
years,
baby.
but
Your
it's
S-
never just going to be the 2 years that they covered. It'll be the 12 years. And so the coverage won't be very much good to you because it won't just pertain to the recent 2 years. It'll be the entirety. So for most cases, it would have to be you would have to have this insurance when you first get a case to make it worth
to
worth
make
it
it the
to
most,
me.
sure, to make it the
Yeah.
most effective, most protection. Most guardians do not even consider E&O insurance for their first couple years. You
Well,
know,
I didn't even know it was a thing
didn't know
until
it was a thing.
recently.
Darren comes to FSGA conferences all the time. He sits there at his table and he talks to people and he does presentations. That's what he's here for today, is to teach you that it's a thing. That's why our peer group exists, is for new guardians to know, oh, I have 2 cases. They're both pro bono. What do I need this for? Perfect conversation today of why you might want to get this now. All right, Diana. Oh, I'm glad you brought this up. Please describe the difference between surplus insurance and state approved insurance. Now we're only focusing on this insurance, just personal liability, not the other kinds. Or professional liability. Go ahead, Darren.
All right. Well, most insurance companies are approved in the state of Florida. There are some what we call unauthorized entities that will put an agent in handcuffs if we utilize those companies.
Wow.
There you have what's called an excess and surplus or an admitted company. What does that mean? Admitted means that insurance company, if they were to go bankrupt, there would be a backstop called the Florida Insurance Guarantee Association that would step in and pay any kind of claims that were pending at that time, up to the dollar amount, depending upon the type of claim it is. Auto claims are at a certain dollar amount, property claims are at another dollar amount, general liability claims are at another dollar amount. It's not the full amount of the policy, but there is some coverage there. Excess and surplus companies are still regulated by the state of Florida. They must have a certificate of authority issued to do business. They are just not subject to the Guarantee Association. But then you have to look at what kind of financials do these companies have. And let's be honest.
Is that going back to the ratings?
You can look at the ratings, you can look at their financials, because it's going to be public information. They can't hide it. The state's posted out there and you can look at it. But we can't get wrapped around the axle on professional liability as saying, well, I want to make sure that they are A+ rated. That's great. Wonderful. We want to work with all of them as well. But $1 million claim or a $500,000 claim is not going to bankrupt any insurance company. There is a different animal compared to, say, a homeowner's policy that can have catastrophic losses and wipe the company out if the Cat 5 hurricane comes into the Tampa, St. Petersburg area or the Miami, South Florida area. Totally a different animal. Then you want to make sure that they do have the adequate resources, and then that they're subject to the guarantee or they have reinsurance. There are all kinds of layers of mechanisms. So looking at that on
Okay,
a
so to
professional
be
liability is it's nice to look at, but that should not be the driving factor.
Okay, so then Darren, to be real clear, and you know I'm pretty frank, I don't go
Yep.
function any other way. Do you have companies that are excess and surplus, companies that are admitted, that you use them and still consider them safe for your customers?
Yes,
Okay.
all day long, every day.
Okay, all right. This comes back to the expertise of a skilled, experienced, knowledgeable professional insurance guy, not something else, and an independent one who has lots of choices. He has lots of companies to choose from, which that's what you want, is you want them choosing from the companies that can give you the best stuff. Okay, all right, it is 4:13. We're technically done, but it's okay, we can keep going. We're legally done, but we can keep going. All right, so let me check for a second. I'm looking for Cindy says, is Darren a broker who will help us? Darren, answer that question.
Absolutely. That's what, I'm here to help you guys. I will be at the FSGA conference again. In fact, I'll be on the main stage talking about professional liability this year in July.
Good. Keith, you got a
And
question?
I'm sorry?
I think Keith is, no, that's not, I don't know. Who's talking? I'm sorry. Somebody have a question?
So before we wrap it up, one other thing.
Okay.
I don't like just coming on here, but I want to help you guys because that's, what you guys do. That's why I got into this, is you guys are helping. What you do for the people that can't take care of themselves, my heart goes out to you guys, so whatever I can do. So I will put up here, I created just for you guys. If you follow the QR code, you go out there, I created a cyber liability checklist for you guys as small businesses, what you need to be looking at, because this is something that needs to be coming up for you guardians. You're dealing with electronics. You have electronic healthcare information. You have access to their banking accounts. You're using it on your cell phone. I'm telling you, using your cell phone for their banking is putting you at risk. Stop it.
Oh my goodness. Okay, you just hit such a sore spot in my body. Okay, guys, real quick, I'm going to thank Darren so much for this, because our world is changing big time when it comes to guardianship. Used to be paper, now it's electronic, and soon it will only be electronic.
Right.
So, okay, so Julie, can you, for people who aren't thrilled about using the
QR code. They can
code,
call me, email me. My contact information is there. I'll get you the.
Darren, is it something Julie can put on the thing to send out when we send out this actual presentation?
Absolutely.
Perfect. Okay. So, I love to function on stories because it makes people finally understand risk. So I'll tell you cyber risk I want you to think about. You're the PR to the gentleman who purchased in the 80s LasVegas.com. This is a real story. He passed away. You're the personal representative to his estate. You've been there for a couple of weeks. You're figuring everything out, all of his stuff, all of his assets, everything. It's 2 days before that domain is going to come up on GoDaddy.com. He bought it in the 80s for $50.
Oh.
It's now worth gazillions of dollars. If you don't get into his email, that decedent that you're the personal representative to be able to get the third-party authorization to his cell phone, to then be able to update and pay the GoDaddy fee, he will lose that, his estate will lose that asset. Someone will outbid it, and they'll have $1 million asset that they'll buy for $200. And you will be coming back to Darren for errors and omission because you didn't take care of this before it was sold at pennies on the dollar on the GoDaddy auction.
Yep.
I tell that story because it's the first time I understood guardians and fiduciaries at risk for not just the physical assets, the car, the house, the condo, the boat, the gold, the jewelry. Now it's digital assets, which is
the newest one, Bitcoin And
Bitcoin.
crypto.
God, it scares
Bitcoin
me.
and crypto.
Bitcoin scares me to death. So this is something great. I'm so happy you did this, Darren, because I talk about this a lot. 10 years ago, this was never even an issue to talk about.
Nope.
Ever. Now it's a big issue. And I like your comment about telling guardians don't use their phone to do wards transactions.
Please don't.
Hardly at all. Hardly at all. It's really not a good idea. It's really not. Oh, good stuff. Good stuff. Okay, so I'm checking for chat to see if we've got quite a few thank yous. We've got invaluable information. Thank you for the presentation. If I'm in, yep, we got that one. All right, I'm checking to make sure we got them all. Sue says he is good to work with. Thanks for the presentation. Extremely helpful. Thank you, thank you, thank you. Perfect. Okay, so before we sign off, is there any other questions or concerns or comments or something else that you guys want to talk about in regards to this presentation?
This is Diana.
Hey, Diana.
I would like to tell you that there is officially a new OPPG executive director. Her name is Mary Ellen McDonald. She may or may not be at the conference in July, but her second in command, Kyle Hammer, is supposed to be there, available to talk.
Woo, thank you.
And just so you guys know, Kyle's been the one that's been really instrumental in helping Kate with CE stuff.
That's the OPPG.
Yeah.
Awesome. And so
he just told me he was promoted to operations director. That there's no longer going to be a deputy director position like Jennifer was. It's going to be him.
Okay. Well, he's been helpful to us. How that relates is, you know, we had this big GSI class last week, however long it's been now. And Kate originally had gotten general CEs, and we got to thinking, gosh, this is not a general course. Well, he was very helpful, and he got 1 hour each for all the hard hitters: exploitation, ethics, law, and the other one. And that's because Kate, Aged, and Kyle worked together well to fix that, which is great. Very much appreciated. Okay, thank you, Diana. I had not heard that yet, so we're excited to hear that there's going to be somebody at the helm of that ship, because that's been a little nerve-wracking. All right, so it's 4:19. Darren, let's talk about this, because you used your time and you committed so much energy to us. What can we do for you?
Absolutely nothing. I just appreciate you guys. I really do. I see a number of my, customers and clients on here. So this is all about you guys. This is to make sure that you guys are protected. Like I said, you guys do yeoman's work out there and you get no credit for it. I just want to make sure that you guys are protected so that these crazies that are out there running around don't financially bankrupt you guys, because they're crazy. And like I said,
crazy.
The lawsuits, they can bleed you dry so fast.
Bananas. They're bananas. For what it's worth, guys, just so you all will know, I was under a lawsuit for 12 years. One lawsuit, 12 years. Don't ask me what I spent. Okay, so let's go to, as a reminder, on the 28th, which is the last Wednesday of the month, that's our 5 p.m. Zoom roundtable where we just talk shop. We don't have a speaker that day and we don't have CEs. We just talk shop, questions, resources, frustrations, venting, figuring out what to do with a form, what to do with a client that you can't figure out what to do with. Diana often talks about her very frustrated situation she has of a gal that won't let her in the house. And she's tried every one of our suggestions. She's tried them all. Oh, thanks, Julie. So here's the schedule of our peer group. We meet a lot. We meet 4 times a month. And please come as often as you can. Plenty of people come when they're driving down the road. They just listen. They don't have their face on the screen. That's fine. Just get this information. What did Darren say? Keep yourself educated, informed, so you'll be a really good fiduciary, which that in of itself reduces the lawsuit opportunities by a lot. So, all right. I think that's really all we got. Julie, is there anything you need? Julie, did I lose you? Okay, I don't know what happened there. Okay, all right, guys. Thank you all so much. Thanks for coming, Darren. I can't thank you enough because this is such a hot subject, and I think you did a fantastic job of making it where I understand it. I hope everybody else understood it, and now we have some clarity. By the way, just as a reminder, this is a business, and this is a business expense. So, yes, I know you're spending money, but it's a business. Remember, guardianship is not a charity where you just work for free all the time, because a lot of guardians believe that. A lot of courts seem to make the guardians want to believe that. That's not the game here. You want to make a living and provide great services, and it's a business expense. So it's a great thing for your CPA to know about. All right, guys, thank you, everybody. Thanks for coming. Darren, thank you so very much.
My
And
pleasure.
I'll see you guys next